Hello my dear friends and welcome to StudyIQ. I am Joycey Joy and today in this lecture we will discuss about the sedition law in India. Let us first look into the current affair. Recently, sedition charges were slapped against a few. We will see that in the recent news, sedition charges were slapped against an Assamese scholar and two others for remarks made against the proposed citizenship law. So this is one example where the sedition law has been slapped on a few individuals in India. So this is the news, and based on this we will understand what is sedition law in India, what is the background of the recent charging of sedition, and also what are the shortcomings. So let us start. Let us first understand what is a background where the sedition law has been slapped on a few individuals recently. As we have discussed, the Citizenship Amendment Bill was the reason for the slapping of sedition law on three people on the charges that they have made some remarks against the proposed citizenship law. Now, the Citizenship Amendment Bill was recently cleared by the Lok Sabha, and the bill seeks to hasten or speed up the process of legalizing the stay of non-Muslims from Afghanistan, Bangladesh and Pakistan who allegedly fled religious persecution and came to India till December 31st, 2014. So, here we will see that this seeks to legalize the stay of non-Muslims. That means Muslims are excluded from the list. And the bill had already faced strong resistance from many sides, saying that this will pave a way for granting citizenship mostly to the illegal Hindu migrants from Bangladesh. About 40 lakh people were excluded from the final draft of the NRC or the National Register of Citizens in Assam that was published last year in the month of July. So the new bill, that is Citizenship Amendment Bill, seeks to negate the NRC, and the recent sedition case was filed against the scholar after he allegedly said that seeking independence from India could be an option for the indigenous people if the centre went ahead with the bill. So this statement was made in a protest rally. So for making such a remark that we need to seek independence from India if this bill is passed, so for making that statement, the scholar and two others were charged with sedition. And also in addition to section 124A, which deals with sedition, they have also been accused of entering into a criminal conspiracy, that is section 121. So criminal conspiracy to wage a war against the government, which includes under 121, and also they were charged of concealing a design to facilitate such a war, that is section 123 of the IPC. So these are the charges made against them. Now let us understand what is sedition law. Sedition in India is defined by 124A of the Indian Penal Code or the IPC. And this section was introduced by the British in India. The British colonial government introduced this in the year 1870. So what was the reason? The reason was that a specific section was needed to deal with the radical Wahhabi movement of the 19th century. Wahhabi movement was led by Sir Syed Ahmad. So in order to tackle or deal with the Wahhabi movement in the 19th century, this anti-sedition or the sedition law was introduced by the British colonial government in India. So according to the 124A of the IPC, whoever by words or either spoken or written brings in any hatred or any contempt towards the government established by law shall be punished. So if a person brings a hatred or a contempt against the government which is established by the law shall be punished. So this is sedition law in India. Now let us understand whether it impacts the freedom of speech and expression. So Article 19 Clause 1 Subclause A of Indian Constitution guarantees every citizen the freedom of speech and expression. This is a fundamental right guaranteed by the Constitution of India. Though the government can impose a reasonable restriction, still Article 19 is a fundamental right. So one criticism against the sedition law is that it is against the freedom of speech and expression. And secondly, Gandhiji was a great opponent of this Sedition Act. And this can also be used to ban certain publications. So this is also against the freedom of speech and expression. And also in the Ramnandan versus the state 1958, the Allahabad High Court held section 124A unconstitutional. So this was declared as unconstitutional by the Allahabad High Court in 1958, stating that it restricts the fundamental freedom of speech. So this is also important here. And also coming to the modern democracies, the modern constitutional democracies like the United Kingdom, the United States, New Zealand, etc. have scrapped anti-sedition laws from their law books. So it is high time that India also needs to follow such type of modern constitutional democracies who have scrapped such kind of law. And in case of India, we will see that in many instances this section 124A, that is sedition law, is misused. And the Law Commission has also called for a reconsideration of this sedition law in India. So in the medium term, the provision can get a narrow definition, but in the long run, section 124A should be scrapped. Now let us try to answer a UPSC Mains model question. The question is, should the sedition law be scrapped in India? Critically analyze. So this is the question, and based on this question, we have to critically analyze this statement. So I'll give you a broad outline on how to answer this question, but you will have to attempt writing this answer, and you can send it to me at joycey.studyiq@gmail.com. So you can start your answer by stating what is sedition law and what is the background. We have seen that British colonial government has introduced the sedition law in India. So you can give the background. Second, you can define what is sedition. You can give the definition under section 124A of the IPC. Next, you can quote what are the concerns regarding the sedition law. For example, the misuse of the sedition law. Give some instances. For example, in the Kudamkulam district in Tamil Nadu, sedition cases were slapped against the village for resisting a nuclear power project. So this has been misused in many instances. You can also give the recent example of the scholar who had been slapped with the sedition law. So you can give the instances of misuse, and next you can give why it should be scrapped. What is the reason for scrapping it? Firstly, it is because it resists the freedom of speech and expression. Article 19(1) subclause A. So it is a fundamental right, and the sedition law in India harms the fundamental rights. Now you can also quote the Supreme Court ruling in this sedition law. Supreme Court has ruled that casual relationship between speech and acts of violence and mere speech does not amount to sedition. So Supreme Court has given this ruling, and this also you can include, and you can explain in the next paragraph, is it time to scrap this laws? So you can mention the examples of the modern democracies like the UK, US, New Zealand, etc., where they have already scrapped the sedition law. And next you can mention about the constitutional validity. You can mention about two cases. One is Ranjlal Modi case in the year 1957. Second is Kedarnath case. So you can mention about these two. And finally, you can suggest some short-term measures. Like in the short run, what can be done? In the long run, it should be scrapped. But in the short run, what can be done? For example, the judicial check. Judiciary must check that police does not act on politically motivated complaints. And second one can be prior sanction of the judiciary before scrapping anti-sedition law. Thirdly, the burden of proof. And fourthly, the court should take action against those who bring malicious complaints or irrelevant complaints. For example, in the case of PIL, we have seen that the court is charging penalty on those who bring in malicious complaints. So this can be done in case of sedition as well. And you should also give a concluding paragraph where you can mention about democracy and the values of democracy, where Article 19, the freedom of speech and expression, holds a key role, and it is also a fundamental right. Secondly, you can mention about the Supreme Court. Supreme Court is the guardian of the Constitution as well as the fundamental rights. So it should protect the fundamental rights, and in the long run, it should be scrapped down or struck down. So this should be the structure of your answer. So based on this structure, please try to answer this question. This is a very important topic for UPSC, especially in the UPSC Mains examination. You can expect questions like this. So please try to attempt this and please send your answers to joyce.studiiq@gmail.com, or you can inbox me on my Facebook page. Thank you.